may find speech offensive is not a sufficient reason for suppressing it. The government must remain neutral in the marketplace of ideas. So, it is reminiscent of Brennan's opinion in Sullivan, where he's talking about the need to have breathing room for public discourse, the need to discuss, even critically, public officials and public figures, and the inherent subjectivity of the standard that had been used here to impose liability. All sounds wrong, and you're just waiting, as in Sullivan, for the other foot to drop, the other shoe to drop, and for Rehnquist to say, and therefore public figures may not sue for intentional infliction of emotional distress if it's allegedly caused by a publication. And he doesn't go there. Like Brennan, he takes a last-minute detour into the actual malice rule and says, public officials, there's the holding of the case, I take it, public figures and public officials may not recover damages for intentional infliction of emotional distress without proving a false statement of fact made with Sullivan actual malice. And because the jury had found that there was nobody would have thought this was factual at all, Falwell loses his case. Well, that's the decision in Hustler. It's an extremely important landmark defense of satire and parody, and is useful not only with regard to claims of intentional infliction of emotional distress, and libel for that matter, but any other kind of claim in which a public figure or a public official claims damages by reason of a publication. If it's the publication of something that they're complaining about having caused them injury, then they can't do an end run around New York Times versus Sullivan by putting some other label on the case besides libel. And lawyers have fertile minds, and they can think up other theories, other labels to put on their lawsuits besides libel. For example, intentional infliction of emotional distress and others. And the message of Falwell, one of the messages of Falwell that's useful in the real world, is that it doesn't matter what label is put on it. If the public figure is complaining about a publication, then he or she has to meet the Sullivan requirements. Falwell was a satire of a public figure, basically dealing with an offensive, mean-spirited cartoon. We might look at some others in recent times, but before we do, yeah, and they used Campari's logo, or it looked like a Campari ad. I doubt seriously that they sought Campari's permission for that. Campari might sue Hustler for trademark infringement, maybe, something like that. I'm not aware that anything like that was done, but misusing Campari's trademark theoretically could give rise to a lawsuit. No, they don't have to prove libel. They have to prove the elements of the tort. But if they're complaining about a publication, they have to identify a false statement of fact in addition to whatever elements of the tort are required. Okay, the Danish cartoons, remember them 5-6 years ago? When a little teeny newspaper out on a peninsula in Denmark had a contest about lampoons of Islamic figures. And this one was the most inflammatory of those that they published, showing the Prophet Muhammad with a bomb ticking in his turban. And I understand that in Islam it's a sin to create a likeness of the Prophet. So this was at least doubly offensive to Muslims around the world, and a fairly organized, orchestrated campaign against Denmark, not just the newspaper, against Denmark, broke out around the world. Its embassy was bombed in a place. 100 people died in riots in Muslim countries around the world protesting against the Danish defense of the newspaper. A boycott of Danish goods was mounted all over the place. It really hurt. And the Muslims claimed that Denmark was allowing the demeaning of the Islamic religion. Right? Well, I'm not sure, but I think there may have been a fatwa against the cartoonist. And just recently I saw there was still another attack on the newspaper's offices in this little town in Denmark. They haven't let go of that issue yet, even though it's several years old. And then in retaliation for the Danish cartoon contest, the president of Iran, Ahmadinejad, I can never say it right, organized a Holocaust cartoon contest in which people from around the Arab and the Islamic world submitted entries, and this one won first prize, showing a wall going up in Israel, walling off the mosque with Auschwitz, the concentration camp from the Holocaust, showing up on the wall, and was obviously meant to be bitterly critical of the state of Israel. And then during the 2008 campaign, there were a series of look-alike cartoons. The New Yorker ran this one on the cover in the summer of 2008, showing Michelle Obama dressed up as a Black Panther, toting an AK-47, fist-pumping with Barack in the Oval Office, with a portrait of what appears to be Osama bin Laden hanging over the fireplace, and a flag burning in the fireplace. And the idea, apparently, was not to satirize the Obamas, but to satirize the lunatic fringe of people who were claiming during the campaign that this is what the Obamas are really like. He's really a Muslim, he's dressed up like a Muslim, she's a Black Panther, Black militant, and we certainly can't trust them. That subtlety that the cartoon was meant to satirize the criticizers of the Obamas was lost on most people, and a lot of people got upset when they saw the cartoon. And then the LA Daily News did a cartoon that basically satirized the New Yorker cartoon, showing Bush with the AK-47, Cheney dressed up in an Arab costume, picture of Richard Nixon over the mantle, and the Constitution being burned in the fireplace. Criticizing government. It was really a parody of the New Yorker cartoon. It's hard to figure out what it satirizes other than that. Maybe it satirizes Bush and Cheney as well. Still another cartoon going out of the same route. Vanity Fair commissioned this one, which is really very mean, about the McCains in the Oval Office. Cindy McCain carrying a handful of pills. Came out that she had some drug problems with prescription medicine and so on. McCain, many thought to be too old to run for president, with a walker. A picture of W over the mantle, and again the Constitution burning in the fireplace. These were all caricatures, all of these cartoons. All of them, I think, were somewhat mean-spirited. Certainly, some, if not all of them, would be considered outrageous to many people. They would upset their targets. They would be offensive to their targets and many other people, hurt feelings, and every one of them is protected by the First Amendment. Largely based on the Falwell decision, which gives that protection to satire. Let me give you another Hustler case, the Hersig case, that doesn't deal with political matters at all, but introduces the subject of incitement and advocacy of unpleasant, hateful ideas. Hersig involved the decisions of the Reader, of course. I'm sure you've digested it well, but let's look. Involved a Hustler magazine article in a series that they do on sex play. The article is entitled Orgasm of Death, and it discusses the practice of autoerotic asphyxia. And this may be familiar to you guys. It's the first time I ever heard of it. And the practice is, as the title indicates, apparently what you do is you hang yourself while masturbating, and as you approach orgasm, you cut enough blood to the brain, and that greatly intensifies the orgasm, and is thrilling but risky. And the Hustler article emphasized, I think 10 times, readers were warned, do not try this, do not attempt. This practice is often fatal. As many as 1,000 United States teenagers die in this manner every year. And explains how to do it, and warns people not to do it. A 14-year-old named Troy D. in Houston came into possession of this issue of the magazine, apparently read the article, hanged himself. He was cut down by his best friend, hanging in his closet with the issue of Hustler open to the article at his feet, dead. And his mother sued Hustler magazine for wrongful death, for having wrongfully caused the death of the son. The friend also sued, and the jury ruled in their favor, awarding damages to the mother and to the friend, as well as punitive damages against Hustler magazine. The case went up to the Court of Appeals for the Fifth Circuit. It didn't go any farther than that. That was the only appellate decision in the case, was the Fifth Circuit decision, in which the opinion was written by Judge Alvin Rubin. And the court split 2-1, with the majority deciding that the First Amendment protected Hustler's article from any liability. The opinion starts out with Judge Rubin saying that the constitutional protection that we give freedom of speech is not based on the naive belief that speech can do no harm, but on the confidence that the benefits that society reaps from the free flow and exchange of ideas outweigh the costs that society endures by receiving reprehensible or dangerous ideas. Under our Constitution, he says, there's no such thing as a false idea. We rely on a reverse Gresham's law, trusting to good ideas to drive out bad ones in the marketplace of ideas. It's sort of like Brandeis's notion from Whitney that we've touched on a couple of times before, that the remedy for speech that you find offensive or dangerous or subversive is not suppression, but more speech. We rely on good ideas to drive out bad ones. But Judge Rubin recognizes that the Supreme Court has recognized that some types of speech, some categories of speech, have always been excluded from First Amendment protection, and lists what are now familiar categories for us: obscenity, child pornography, fighting words under the Chiklinski decision, the Jehovah's Witness case, incitement to imminent lawless activity, which we'll come back to, libel, fraud, and so on, and points out that this Hustler article doesn't fall into any of those categories. It's not obscene under the requirements for obscenity that we've looked at and we'll look at a few times more. Hustler's not in one of these categories. So then the question is the speech in this article subject to government regulation under the notion that a restriction on it is needed to serve a compelling government interest, and the restriction is narrowly tailored to serve that interest. In other words, to use the kind of balancing test that the Supreme Court uses in all these modern cases. Then Judge Rubin looks at what the contention was in the trial of the Hersig case, which the theory of the case was not intentional infliction of emotional distress or some other tort like that. It was rather that Hustler was guilty of incitement of imminent lawless activity and likely to produce violence or harm, and therefore was unprotected speech. So did the article incite Troy D.'s death? The judge says, was entitled to consider the evidence that there was nothing hypersensitive or abnormal or goofy about Troy D., that he was simply a normal 14-year-old teenage boy. Well, the court says that they're doubtful that a magazine article that's no more direct than this one could ever constitute incitement of the kind involved in the Supreme Court decision in Brandenburg versus Ohio, which is the case on incitement. So let's look at Brandenburg. How are we doing on time anyway? Okay. Clarence Brandenburg was a Ku Klux Klan official in Cincinnati, I think the leader of whatever they are. And he called up a local television reporter in Cincinnati and told the reporter that the Klan was having a rally on a farm out of somewhere in Hamilton County, Ohio, and invited the television reporter to come with a camera person and cover the rally. So they did. And they went out and they discovered a bunch of men in their full Klan regalia with hoods and robes and stuff. And they were saying a bunch of ugly things, racist things. Personally, I believe the nigger should be returned to Africa, the Jew returned to Israel, and stuff of that ilk. All of this was filmed by the television station. And Brandenburg made a speech in which he said that we are not a revengeant, it's not a word, we are not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. And all of this is filmed by the television station, leading to the prosecution and conviction of Brandenburg under an Ohio statute, an Ohio law, of the same vintage as the law involved in Yetta Stromberg's case, the 1919 Bolshevik era statute that prohibited advocating the duty, necessity, or propriety of crime, violence, or other unlawful methods of terrorism as a means of accomplishing industrial or political reform. And because of his speech, Brandenburg was fined $1,000 and sentenced to 1 to 10 years in prison. The case went to the Supreme Court, which reversed the conviction, reversed the actual holding of the Whitney decision, the 1927 decision that Brandeis had written his wonderful opinion in, that had upheld a California law that is very much like almost word for word the same as the Ohio law. And the court said in the Brandenburg case that all these decisions from the World War I cases and up till now have thoroughly discredited the notion that speech that advocates the overthrow of the government can be prohibited. The constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. The mere abstract teaching of the moral propriety or even the moral necessity of a resort to force and violence is not enough. So the court has drawn a distinction between advocacy of the worst ideas, which is protected, and incitement, which is unprotected. And it's not easy to identify the bright line between those two categories. In my mind, for example, advocacy could be in a book that advocates racial segregation, for example. And even though it's wrong and it violates our moral standards about what kind of society we want to be, it's protected if it's advocacy. But if the conduct is standing up on the barricades with a lighted torch and a mob behind you and yelling, "Let's burn it down," that's probably incitement, and that speech is not protected. Well, that was the Brandenburg decision, and the court applied that in the Hersig case because the theory of the claim against Hustler in the death of the 14-year-old boy was that Hustler had incited his death. And the court discusses the Brandenburg standard directed to inciting or producing imminent lawless action and likely to incite or produce such action, and looked at this article in Hustler and said there's no fair reading of it, which would make its content advocacy even, much less incitement. Hustler isn't advocating that people try autoerotic asphyxia. It has 10 warnings against it. Don't do it. That you can hardly call it advocacy, and certainly you can't call it incitement. And therefore, the court concludes that Hustler did not incite the death within the meaning of the Brandenburg standard, and therefore is not liable for causing Troy's death. The plaintiffs in the case, Hersig and Best Friend, said that, well, you shouldn't use that Brandenburg